Good morning. Since we are in a highly developing area, multi-storied buildings are being constructed. All money and being siphoned, laundered, and huge buildings investments were made. Leave that, but being advocate and also uh, as social part of this universe must know certain things. This one, just like we are now slowly uh, learn how to operate cell, touch system, and then computer, then downloading, uploading, cutting and pasting, so many things. This is also most important. This is a case pertaining to plot, how plots are being purchased, and what will be the subsequent problem. So, is it necessary to read the entirety of the agreement before signing or enter into after paying initial amount? So many things are there. This judgment is AR 2023 Supreme Court 4503. So the cause of action arose even prior to RERA Act. Therefore, this case was adjudicated before Consumer Forums. AR 2023 Supreme Court 4503. Experian Developers Private Limited versus Imanshu Devan and Sonali Devan and others. Here, the housing project developer subsequently wanted to collect because increased the sale area of apartment. So they have filed a case before the Consumer Forum and that was opposed. So the issues before the Supreme Court were this. Number one, whether the complaint was within the time limit as stated at 69 of the Consumer Protection Act, and that then the cause of action for filing a complaint arises when, whether the initial date of request or when the complainant asked for the details and the calculation of the enhancement of this sale area. So that then another question was they say the doctrine of merger, because they referred one Pawan Gupta case wherein another buyer seems to have filed a case and that was negativated, and when he applied appeal to Supreme Court, that was dismissed in limine. So the res judicata as well as doctrine of merger was also one of the questions. So the answer, you go through the entirety of judgment so that particularly I want you to take paragraph 4. What is sale area? So you have to keep in your mind, if you are already in possession of plots, these all are the most important. Periphery walls, balconies, deck area under the columns and veils, half of the area of wall common with other premises, cupboards, projections, area utilized for the common services, facilities provided, so many things, corridor, refugee, which are not included is retail shop, sites for retail shop and other commercial area in the project. Amenities such as schools, medical center, dispensary, creche, other health centers and the like. Dwelling units for the economically weaker section as prescribed of the applicable laws. Car parking spaces. So these all are the most important. You have to read, understand independently, collectively. So the ratio, the Supreme Court has said, since the cause of action arose only upon the total valuation as to how the builder has calculated the increase in sale area. Therefore, the application was in time. So even otherwise, the National Commission or any other commission has got right to condone the delay if the reasonable excuse was exhibited. So then the question also they say the Rejudicata is not applicable because that case of Pavan Gupta, neither this builder nor the complainant purchaser was the party to this. Therefore, they say doctrine of merger or rejudicata would not apply. So kindly go through the judgment. It's a very best judgment. Best wishes.